I'm going to do about an hour on attorney's fees. I was asked to talk about the Equal Access to Justice Act, but in order to understand the Equal Access to Justice Act, you first have to understand the general principles concerning fee shifting in United States law. So you can see I start with the general principles. Well, the general principle that is the undergirding of the attorney's fees shifting doctrine in American law is the so-called American rule, and that's best exemplified by the Supreme Court's decision in Alyeska Pipeline versus Wilderness Society. The American rule says that attorney's fees are not ordinarily recoverable by a prevailing litigant in federal litigation in the absence of a statutory authorization. So put simply, put in ordinary words, a judge just can't award attorney's fees because he or she thinks it's an appropriate thing to do and that it would serve the public interest. So for instance, in Alyeska, the plaintiffs had succeeded in litigation to prevent issuance of government permits required for construction of the Trans-Alaska oil pipeline. The plaintiffs sought fees, and the lower court said that they were entitled, but there was no statutory authorization for any fee award. The lower courts nevertheless held that the plaintiffs had acted to vindicate important statutory rights of all citizens, had ensured that the government functioned properly, and were entitled to attorney's fees lest the enormous cost of litigation of this kind, particularly against well-financed entities like an oil company, would deter private parties from who desired to enforce important public laws like the environmental laws. And of course that's true. Without the ability to recover attorney's fees, it's going to be very hard for public interest type plaintiffs, whether they're poor individuals who are abused by governmental conduct, police misconduct, whatever it might be, or a case like Alyeska involving environmental wrongs. It's just unlikely that you would be able to bring a lawsuit like that unless you were able to recover your attorney's fees. But the Supreme Court had spoken, and here's what the Supreme Court said. The Supreme Court held that plaintiffs can't recover attorney's fees on the notion of being a private attorney general, that you're doing the public good, because only Congress and not the courts can authorize an exception to the American rule. Recall that I said the American rule is the basic rule that parties in American litigation bear their own costs, including their attorney's fees. So, but as it turns out, Alyeska itself was overruled just a few years later in the Civil Rights Attorneys Fees Act of 1988. But before I go into that, let me back up a second and explain that in American statutory law, there are approximately now 200 exceptions to the American rule, taking their cue from the decision in Alyeska. The Congress enacted many fee-shifting statutes that allow mainly public interest type plaintiffs, whether it be environmental, consumer, and other public interest laws, to enforce those through not only the remedies provided by those laws, for instance, injunctions and damages, but also through an award of attorney's fees when they prevail. So the sort of grandparent of all the fee award statutes is the one that overruled Alyeska. Again, I'll mention it's the Civil Rights Attorneys Fees Act of 1988. And what it says, and I'm not going to read it verbatim, but it says that anytime you sue successfully to enforce a lawsuit under Section 1981, Section 1983 of Title 28, Title 42 of the U.S. Code, these are the statutes passed in the aftermath of the Civil War to enforce civil rights. Anytime you sue to enforce those laws and you win, you're entitled, generally speaking, to an award of attorney's fees. I'll mention a few things about it. First of all, that law has been expanded. It now applies to the Civil Rights Act of 1964, which is an important civil rights act that has to do with employment, discrimination in employment and discrimination in public accommodations. It now applies to the Americans with Disabilities Act, which is Section 1391 of Title 42. And as I say, there are all over the United States Code about 200 of these fee-shifting statutes. But I want to read to you very briefly the words of, part of the words of Section 1988. That's the Civil Rights Attorneys Fees Act of 1976, because it exemplifies the wording of all these other 200 statutes. And it says that when a party prevails, the court may allow the prevailing party a reasonable attorney's fees. And so now I'm going to talk about both three items that I've just mentioned. The may allow attorney's fees, that you have to be a prevailing party to get attorney's fees, and that the attorney's fees must be reasonable. Okay, so let's talk about this. As I said, just to reiterate, there are about 200 federal fee-shifting statutes. They generally apply to civil rights cases, consumer protection cases, environmental cases, but some of them go back a long way. So for instance, the fee-shifting statute in the antitrust laws was enacted in the early part of the 20th century. Anyway, there's many of these, so let's move along and talk about those three words, and three words in the statute. So what is a prevailing party, and when are you entitled to fees? So the basic rule, and I'll read it to you, this comes from a Supreme Court case called Newman versus Piggy Park, is that someone who succeeds in a civil rights suit of the kind I've been talking about should ordinarily recover an attorney's fees unless special circumstances would make such an award unjust. What the courts have said is that there's very, very rarely a special circumstance. So even though the statutes all speak in terms of discretion, and that a court may award attorney's fees to a prevailing party, when the prevailing party is the plaintiff, the one who's trying to seek to enforce the civil rights laws, or the environmental laws, or the consumer laws, ordinarily the court is supposed to award a fee, despite the fact that the statutes use the word may. May has been construed by the courts to mean should in almost all circumstances. So that's an important aspect of it. So then you ask, what about prevailing defendants? What happens when the defendant wins? Now, if you ordinarily granted a fee when a defendant prevailed, that would be a great discouragement for plaintiffs for bringing lawsuits, because if they lost, and these cases are difficult, they don't win all the time, then they would have to pay the defendant's attorney's fees, and that would discourage plaintiffs and their lawyers from bringing lawsuits. Well, the Supreme Court held in a case called Christiansburg in 1978 that in this case, when you're talking about prevailing defendants, may means almost never. So it's it's the kind of statutory interpretation that the Supreme Court would not do these days because they're so focused on the statutory text. But looking at the statutory purpose, they said, look, the purpose of these fee-shifting statutes are to encourage plaintiffs to bring lawsuits. So for prevailing defendants, we will only allow them an attorney fee if the plaintiff's suit was objectively frivolous, unreasonable, or without foundation. So those are the two basic rules. Plaintiffs almost always get fees in these civil rights type fee-shifting situations, and defendants almost never get them, even though we're interpreting the same word, may. So now I want to turn to another word that I underscored. What does it mean to prevail? Well, it doesn't mean to prevail on every little thing. The basic rule is, and this can be seen in a lot of Supreme Court cases, I'm going to quote to you the formulation used in a case called Texas State Teachers Association versus Garland School District, the 1989 Supreme Court case, that a party must, quote, succeed on any significant issue in the litigation that achieves some of the benefit that the party sought in bringing the suit. That's a fancy way of saying you don't have to win on anything as long as you win on something of substance. So if you have a 5-claim case and you win on one of them. To use an example, let's say that the plaintiff in an employment discrimination case has sought an injunction so that she can go back to work, absent the discrimination, so that she can get her damages in light of the discrimination. But also she claims that she was retaliated against for bringing the lawsuit in the first place, or going to the administrative agency claiming discrimination. And let's assume for a second that the jury does not agree that she was discriminated against, and so is not entitled to any damages or back pay or an injunction, but she is entitled to relief because she was retaliated against. That is easily prevailing under the Supreme Court's basic rule of what it means to prevail. You only have to prevail on something of substance to be a prevailing party and be entitled to some fee. So that's the question of what it means to prevail. That's the basic rule. Now I'm going to tell you about some other things. So, as you might imagine, there are rules about how you grant attorney's fees when your success is only partial. And the most important case from the Supreme Court on that topic is a case called Hensley, a 1983 case. And the case goes on at some length describing examples of what it means to partially prevail, but I'll tell you the basic rule. That if you have two claims that are quite distinct from each other, in which the proof would be quite different, then if someone partially prevails, they're not going to be entitled to a full fee. You'd be able to disaggregate the time that the person, the lawyer that is, spent on the prevailing claim from the hours that the person spent on the non-prevailing claim, because the claims are fairly distinct, and you would award just a partial fee because the person partially prevailed. But in a case like the one I described, well, maybe the one I described isn't the best example, but let's say that you had two different theories about why the plaintiff was discriminated against, but they all arose from the same type of conduct. But one theory was a theory of constructive discharge, that the employee had made was so discriminatory that it made life hell for the plaintiff, and she up and quit. That's argument number one. And you also say that she's entitled to damages because at one point during her tenure as an employee, she was demoted, also on account of discrimination. Let's say because the employee was African American or a female, and there was discrimination on those bases. Those two claims, the constructive discharge claim and the claim of demotion, are likely to be highly related, that they're about the same type of discriminatory conduct. And it just so happens in the law of discrimination that it's very hard to prove a constructive discharge claim. And so the plaintiff loses the constructive discharge claim, but wins on the principal discrimination claim about the demotion. In that circumstance, it's likely that the plaintiff's lawyer, and therefore the plaintiff, would get a full attorney fee, even though there's only partial success, because you really can't disaggregate the time. In other words, the lawyer would have had to do all the work if she brought only the demotion claim. So that's the question of partial success. And then the next question is, do settlements count? And I should tell you that in the many, many years of litigating in the district courts and in the circuit courts and in the state courts, under fee-shifting statutes, it was always the understanding that settlements did count. So that if you settled a case and you could show, and it was often very easy to show, that the settlement was on account of the lawsuit. You brought a lawsuit, the parties were litigating it, maybe they took some discovery, and the defendant decides that I don't want to go to trial, I want to try to settle this, the case is settled. It was for many, many decades of the law that was enough to get a fee under these fee-shifting statutes, if, as I just said, you could show some causation between the settlement and the lawsuit, which you could almost always show. But the Supreme Court held in 2001 in a case called Buchanan that actually private settlements were not enough, that a private settlement alone was not enough to give the plaintiff prevailing party status. So this precedent, was a big blow to plaintiffs' lawyers. And here's why. Mainly in cases seeking injunctive relief, you're trying to get a defendant to do something different. The defendant, if the defendant sees the handwriting on the wall and just says, okay, we're going to give up, we're going to give you the injunctive relief you want, that's a settlement. And when that occurs, they can just stop their conduct, agree to some sort of injunction, and the case is over. The case could be dismissed then on the basis of the settlement. And there's nothing the plaintiff can do to keep that case alive. Let me use another example. Let's say that the litigation was about a right to getting documents from the government, whether a state government or federal government, under a Freedom of Information law. The only type of relief available in that type of lawsuit is an injunction. Please hand over the documents. Or a court, make them hand over the documents. Again, if the defendant sees the handwriting on the wall, after years of litigation that might be very costly for the plaintiff, and they hand over the documents, that comes under the rule of the Buchanan case from 2001. It's a private settlement, and you get no fees. So what the court held is private settlement is not enough, that the plaintiff needs a favorable judgment on the merits or a court-ordered consent decree. In other words, some kind of judicial imprimatur that the defendant has done something wrong. As I say, this case was a big blow to the plaintiffs, particularly in cases where no damages are available. You can see where damages are available, the plaintiff can always keep a case alive by holding out for more damages. And so that's a way around the Buchanan rule, but that can't be done in cases where injunctive relief is the principal or only relief. So this is a big problem. It remains a big problem. It has been overruled, and let me give you that example. In just one instance, the Congress overruled it with respect to Freedom of Information lawsuits. And you might want to ask why, and I think maybe our viewers might be interested in why. And it's because everybody knows nowadays, as opposed to years ago, nowadays Congress doesn't overrule judicial decisions that people are unhappy with, by and large, because the Congress is so split on everything. But it turned out, with respect to the Freedom of Information law, there were some Republicans who were very big proponents of freedom of information, including John Cornyn, who used to be the Attorney General of Texas and believed very strongly in freedom of information laws. So the Buchanan decision was overruled with respect to, only with respect to the federal open government law. And I point this out only because I think it's an interesting sidelight here. It's a very important decision, the Buchanan decision. It's very bad for plaintiffs, and it's very hard to get these things overruled. And I think that's an interesting story. I'll show you the language that was added to the Freedom of Information law, because if any of our viewers are interested in doing this kind of legislative advocacy on this topic, this is the kind of language you would look for. So the fee-shifting provision of the federal Freedom of Information law was amended to say that not only judicial orders can give rise to an award of attorney's fees, but a voluntary or unilateral change in position by the agency, as long as the plaintiff's claim is not insubstantial, meaning as long as it's not a frivolous claim and the party has handed over the documents, you get your attorney's fees. And this had an immediate impact. Instead of making the world very difficult for Freedom of Information plaintiffs and their lawyers and contracting that segment of the legal community, it opened back up the segment of the legal community to where it had been before. Under Buchanan, it made it almost impossible for a private lawyer to be a Freedom of Information lawyer unless they had wealthy clients. So that's an important thing. So the Buchanan rule is something to remember. The next topic I want to talk about is fee calculation. Remember, I talked about 3 words in those fee statutes, prevailing party was one of them, and reasonable fee was another one. So when we're talking about a reasonable fee, we're generally talking about fee calculation. So let me just describe the math. The math goes back again to a case called Hensley versus Eckerhart, a 1983 Supreme Court decision. This built on decisions from a couple decades in the lower federal courts that the initial estimate of a reasonable fee is just taking the number of hours that are reasonable and multiplying it by a reasonable hourly rate. The fee shifting law generally calls that the lodestar. When you multiply the reasonable hours by a reasonable hourly rate, you get the lodestar. Typically, when a plaintiff has won a case, like most litigation, the fee is settled, and then you would settle the fee based on the plaintiff's lawyer giving the defendant's lawyer this reasonable calculation of the hours spent on the case multiplied by...
Right now?
Okay. So now we turn to the question of fee calculation. That's the question of what's a reasonable fee under the fee-shifting laws. And again, the word reasonableness comes from these fee-shifting statutes that talk about giving a prevailing party a reasonable fee. So the first issue under fee calculation is just the basic math. And the Supreme Court held, again, I've mentioned this case before, in Hensley versus Eckerhart, a 1983 case, that the initial estimate of a reasonable fee is just a mathematical proposition. You multiply the reasonable number of hours expended on the litigation by a reasonable hourly rate, and you get what the case law calls the lodestar. The Supreme Court of the United States first said this in 1983, but this built on several decades of law from the lower courts. And so what a lawyer does, and I'll show some examples of this later, what a lawyer does is just put together a contemporaneous list of all the work that the lawyer has done on the case, and then tries to come up with a reasonable hourly rate. So now let me turn to the reasonable hourly rate. The reasonable hourly rate is basically a look to the commercial market. So over a number of years, for instance, in a case called Blum versus Stenson, a 1984 case from the Supreme Court, a reasonable fee is the rate prevailing in the relevant community, regardless of whether the plaintiff is represented by a pro bono, private, or a nonprofit counsel. So just because the lawyer is not charging any fees, you look to the commercial rate. In fact, all of the questions that get resolved about whether a rate is reasonable is really a question about whether the rate is commercially reasonable. Now, why do the courts do this? It's to, again, to encourage lawyers to take these kind of important public interest cases. So commercial reasonableness is the key. So if we go back to this notion of a lodestar calculation, and let's assume that the lawyer spent 100 hours reasonably on the litigation, and that the commercial rate in this lawyer's community for someone with 20 years of experience like that lawyer is $400 an hour, then you would have a $400 reasonable hourly rate multiplied by the 100 hours. I believe that gets you to $40,000, but I'll let other people do the math. So that's those three. That's the basic law. And I was asked to talk a little about the Equal Access to Justice Act, which is a special fee-shifting statute. But I didn't think you could understand the Equal Access to Justice Act unless you understood the basic general principles. And that's why I went over them. So with those in mind, let's turn to the Equal Access to Justice Act, which is also known by its acronym EJA, E-A-J-A. It's codified at 28 U.S.C. 2412D. And let me explain first, just in non-statutory language, what the statute applies to. It is the principal fee-shifting statute applicable to cases against the federal government when no other fee-shifting statute applies. It was passed in 1980. And so, let me give you an example where it doesn't apply so that you can understand the kind of things it does apply to. So for instance, under the employment discrimination statutes, which I've given an example of fee shifting under them, remember I used the example of someone suing for discrimination on the basis of constructive discharge and a wrongful demotion. If that case had been brought against a federal employer, say I worked for a federal agency such as the Department of Commerce or NASA, and I say I was discriminated against, the Equal Access to Justice Act would not apply because the anti-discrimination laws that apply to the private sector also apply to federal employers, generally speaking. So you would just go to the fee-shifting statute under the anti-discrimination laws. But the Equal Access to Justice Act applies to all other wrongful government conduct that's unlawful. So for instance, if I sue the government because I've been wrongfully denied my disability benefits or my veterans benefits, or because there's been some unreasonable governmental action. So a public interest organization sues the Food and Drug Administration for wrongfully allowing a drug onto the market that's harming people, or has sued the Occupational Safety and Health Administration for issuing a rule that is not protective enough of workers' interests on the job in dealing with hazardous substances, cancer-causing substances, and you prevail in those type of litigations where no other fee-shifting statute applies, then the Equal Access to Justice Act applies. So that's important. It's an all-purpose sort of cleanup statute regarding the conduct, the wrongful, illegal conduct of the federal government. So again, to want to focus down a little, to go back to my example, so why is it that a lawsuit against the Occupational Safety and Health Administration needs to rely on EJA for fee shifting? The reason is the law that you would sue OSHA under because it did not properly take care of workers' interests in being safe from carcinogenic substances is the Administrative Procedures Act. And the Administrative Procedures Act does not have a fee-shifting statute, and so EJA applies. So I asked the question, in what kind of cases? Well, I just described to you what kind of cases, but I'll read to you the statutory language and you'll make sense of it. Except as otherwise specifically provided by statute, a court shall award to a prevailing party the fees and expenses incurred by that party in any civil action, including proceedings for judicial review of agency action, that might apply to my OSHA example, brought by or against the United States in any court having jurisdiction of that action. So even if the court, for instance then, even if the United States brings an action against you as a citizen, say to try to recover property or to condemn your property under a theory of eminent domain, and you win, you could use EJA to get an attorney's fee. So why am I bothering with EJA and why was I asked to address it? It's because EJA, although it used the prevailing party formulation, has some attributes that are quite different from the other statutes that I've been talking about. And most of them are less generous. It's important to know about them. So let's turn to those things. First of all, you have to be eligible for EJA fees. There's a net worth requirement. That's what the net worth requirement is, the statutory provision that people are referring to when they speak of eligibility. So let me speak first about the contrast and then I'll turn specifically to EJA. I could be either the poorest person in the world, in the United States, or the richest, And if I win an employment discrimination lawsuit under the Civil Rights Act of 1964, I'm entitled to a fee regardless of my net worth. The same would be true of the environmental laws, most of the consumer protection laws, and so forth. But EJA is different. There's this net worth requirement. And if you're an individual, you are not eligible for a fee if your net worth exceeds $2 million at the time the lawsuit was filed. Now, $2 million net worth is fairly substantial. And I can tell you that the most EJA cases are cases involving wrongfully withheld Social Security disability benefits, wrongfully withheld veterans disability benefits. And so those are the two principal categories with individuals, and most of those people are not people with net worths over $2 million. In fact, that's an understatement. The vast, vast majority of people who are challenging wrongful government conduct because of the withholding of Social Security or veterans benefits are relatively poor. But there is that requirement. So, for instance, if the government, you've gotten into a contract dispute with the government contract cases are cases that are contemplated by EJA, but you're an individual who had a contract to do some services for the government, and there's a dispute about, say, a $10 million contract, and it turns out that your personal net worth is $3 million. You win the lawsuit against the government. You may not get an EJA fee because you don't pass the threshold eligibility requirement. There is also a net worth requirement for entities. The entity requirement is $7 million at the time the civil action was filed. It's not really a requirement, it's a threshold. If you're under that threshold, you are eligible for award of attorney's fees. But if your business, your entity, has a net worth of over $7 million, then you're simply not eligible. Even if that entity, to use the government contract example, your small corporation, the court holds, was ripped off under this contract. If the company's net worth is $8 million, you're going to have to bear your own attorney's fees. But there is an exception, and a very important one, and I'll read it because I want to stress it. Except that an organization described in Section 501c3 of the Internal Revenue Code, in other words, a nonprofit organization to which charitable contributions are tax deductible, a nonprofit, may be a party eligible for fees regardless of the net worth. So nonprofit organizations, regardless of their size, are eligible for EJA fees, and that's an important exception to the net worth requirement because, as I was just indicating with some of my examples, cases against government agencies that have engaged in wrong conduct, for instance, like the Food and Drug Administration example I used, or the Occupational Safety Health Administration example I used, they are eligible for EJA fees, even if they're, large organizations like the ACLU, which obviously has a net worth of greater than $7 million. So let's move on. The next thing that's important that makes EJA different from the other statutes is also best described by comparing it to the run-of-the-mill fee-shifting statutes. As I noted, once you've prevailed, you are ordinarily entitled to a fee because the Supreme Court held, as I noted, that when the statutes say a court may, in its discretion, award a fee, the Supreme Court has held, because of the purposes of these laws, that means generally all the time you should be getting a fee. But that's not so under the Equal Access to Justice Act, because the Congress says a court shall award to a prevailing party fees and other costs incurred. So that sounds pretty good up front. It makes it sound like the fee is mandatory. But if you read on in 28 U.S.C. 2412 D1A, the court goes on and says, you shall award this fee unless the court finds that the position of the United States was substantially justified. Now, what does substantially justified mean? The courts have said what that means, and I'll speak about it in a second. But note that it says unless the court finds. So it seems to say, and the courts have held, that the plaintiff is entitled to a fee unless the United States can prove otherwise. So it sounds like, and the courts have held, that the burden is on the government of defending the request for fees by showing that its position was substantially justified. Well, what does that mean? That's actually a tricky question because, gosh, I'm a plaintiff and I just won. So I tend to think that the position of the government was not substantially justified. It sounds like a contradiction in terms, in fact, that you can win under whatever the standards are for winning this kind of lawsuit, and then the government can turn around and say, well, but wait a second, yes, I lost, but I don't have to pay a fee because the position I've taken was justified, or in the words of the statute, substantially justified. But the statute says this, so the courts had to try to make some sense out of it. And what the Supreme Court said in a case from 1985 called Pierce versus Underwood, the court said that substantially justified means having a reasonable basis for your position in law and fact. So what that means is that, yes, you may have lost, but the positions that you were advancing, either in court or in the administrative process that led up to court, were reasonable. Now, that had a reasonable basis in law and fact. Now, that's fairly vague. In fact, that seems to be taking one set of words that are fairly vague and substituting them for another set of words, substantially justified, that are equally vague. But the way the courts have been able to work this out is they've looked to the underlying standard for proving liability in the case in the first place and said to themselves, well, in this case, the standard was just a preponderance of the evidence. So yes, if the plaintiff won, but just by a preponderance of the evidence, yes, it's plausible that you could say that the government's position, even though not a winning position, was reasonable, and they just happened to lose the case. So sometimes in those circumstances where the burden is something like just a preponderance of the evidence, sometimes the courts do turn around and say the government's position was at least substantially justified, and therefore the government does not have to pay a fee. But let me give you another example, and I'll use the OSHA example. Remember, I posited a situation where someone's saying, we need to strike down this agency rule because it's not being protective enough of people who work in this workplace that are being exposed to a carcinogenic chemical. And when you win a case like that, you've, generally speaking, already surmounted a pretty high hurdle. And the reason is that typically in an administrative proceeding, you have to show that the government's position on the merits was arbitrary and capricious or unreasonable in some way because of the underlying substantive law. Well, you can see where if you've got a ruling that this OSHA regulation is illegal and was arbitrary and capricious or otherwise unreasonable, it's going to be pretty hard for the government to turn around and say, but our position was substantially justified. That is, that our position was reasonable in law and fact. So what you do find in the administrative cases, such as the cases against Social Security, against agencies like the FDA and OSHA, against the Department of Veterans Affairs, in those lawsuits, when you win, almost 90% of the time, the fee is going to get paid because the government either concedes that its position was not substantially justified or the court finds that the government's position was not substantially justified. But that's an important difference. The substantial justification defense is an important difference in EJA that is not present in all the other fee-shifting statutes. So there's another thing that's different about EJA, which is the timing of EJA fees. Lots of courts, for those of you who are practitioners will know this, lots of courts either looking to the rules of civil procedure or to the local rules of court, or if you're in a state court, the state's local rules or practices require you to move for certain types of relief within a certain amount of time. You frequently can get an extension of those times, and sometimes they're rather loosely enforced, or the judges themselves come up with their own rules about it. But EJA is different. EJA has its own requirement built into the statute, and you must file a fee application within 30 days of when the judgment in the case is final and no longer appealable. So if we got a favorable judgment in a case in 30 days, and the time period for appealing was 60 days, which it typically is in cases involving the federal government, you had better file your EJA application within 90 days, or you're likely going to be out of luck. It's important to note this because people who do EJA applications for the first time sometimes overlook this. Why do they overlook it? Because no other federal fee-shifting statute has such a rule. So you'll want to be aware of that. So I want to turn now to the amount of fees in EJA cases, because this differs greatly from the amounts available in ordinary fee-shifting situations. Remember, I said that in the ordinary situation, you're entitled to a fee based on commercial reasonableness. And you take the reasonable hourly rates. I posited an example of $400 an hour, multiplied by the reasonable number of hours, and there you have it, 100 hours, $40,000 in fees. But there are 4 things to know about the amount of fees in EJA case. First of all, there's a statutory dollar maximum. The statutory dollar maximum is $125 an hour. That was updated in the statute in April 2006. That's the last update. And then the statute has an inflation adjuster. The statute goes on to say, unless the court determines that an increase in the cost of living requires an upward adjustment. And so what the courts have done, because in virtually every place in the country, with respect to virtually every lawyer, $125 an hour is not going to be market rate. Courts automatically add the inflation adjuster. What's the inflation adjuster? It's looking to April 2006, taking the federal government's inflation statistics, which is published by the Bureau of Labor Statistics, and what the courts do is they look to the so-called all items index, which is the basic measure of inflation in the economy. You say, what is the percentage difference? What is the percentage increase, of the cost of living from 2006, April, till the present? You then adjust the $125 per hour and you get the hourly rate. I can tell you, because I work in this area from time to time, that the rate is now about $200 an hour. So in the last, the last 12 years, I guess that says there's been about an 80% inflation, okay? So that's the second thing to know about fee rates that is different from the ordinary situation under fee shifting statute. There's a dollar maximum and a nearly automatic inflation adjuster. The third thing I need to tell you about is a case called Pierce versus Underwood in the Supreme Court. And that, I think I mentioned Pierce before, it's a 1985 case. EJA says that you can increase the $125 hourly rate for the cost of living, or, and now I'm quoting the statute, a special factor such as the limited availability of qualified attorneys for the proceedings involved. If you have that limited availability, in theory, that can justify a higher fee. So one might think, if you were to look at that language, that, well, if it was hard in the relevant community to attract lawyers at $200 an hour, the inflation-adjusted rate, well, the court could give you a higher rate because there's a limited availability of lawyers. So one might look at that part of the statute and said, well, you could nearly replicate the ordinary statute, the non-aegis statutes, because you could make this argument about limited availability of qualified attorneys. Again, why could you do that? Because you could say limited availability of qualified attorneys is a way of saying, gauging the market and saying, well, you can't get a good lawyer for $200 an hour. And I think that is largely true, particularly in the urban areas of the United States, that around the country, that you just don't find lawyers charging less than $200 an hour, particularly if they practice for any given amount of time. That may not be true in certain parts of the country. So you would think that would be a good argument, but Pierce versus Underwood held otherwise. It held that getting a special factor adjustment required more than showing that. It required that you show some special difficulty in this case, type of case, in attracting counsel at all. And it gave us two examples. So for instance, if you needed someone who had scientific expertise, in addition to their generally lawyerly knowledge, as you often have, for instance, in patent law. So patent lawyers are very frequently also scientists or have some scientific background. The court used an example of patent lawyers. The other example it used is American lawyers who have expertise in foreign law. So one thought after reading Pierce versus Underwood that, well, at least you could try to make an argument that I have some specialized knowledge because I'm an expert on environmental law, or I'm an expert on this or that. But the lower courts read Pierce very, very narrowly, and I think the reason they did is because the opinion in Pierce appears to be very narrow and even harsh. And so basically the lower courts have held this applies only to patent lawyers and lawyers with deep expertise in foreign law and nowhere else. In some courts in the Ninth Circuit, it has also been applied to environmental law. But this is a long-winded way of telling you you're basically just going to get the $125 plus inflation. So currently, you're going to max out at $200 an hour, except in very rare circumstances. So that's the third thing about how you calculate fees. And then the final thing I wanted to talk about is, and this is maybe the most practical thing for folks viewing this, is what are the nuts and bolts of filing the application? First of all, you have to keep and file with the court contemporaneous time records. And you want to make sure that the time records are detailed. So instead of saying in your time records, I worked on a brief, it would be much better to say something like the following. I researched and wrote section 1A of my opening summary judgment brief concerning the Social Security Administration's failure to rebut the claim that my client had a heart condition. Now that may be a little too much, but the lower courts are very uncharitable to fee applications if they just said, did research, worked on a brief, and they will slice and dice your fee request and cut it down if it doesn't have some detail. And the other thing you want to do is you want to put in fee affidavits explaining your work on the case. So not simply put in your hours, but you, like I said, with descriptions of your work, but an affidavit describing your credentials, describing your expertise, if any, in this area of the law, and giving a narrative of what you had to do on the case. The client came to me, I had to understand what the client's situation is, I had to interview her family, I had to interview her friends, I had to build the case. So providing a narrative gives some oomph in addition to just having these bare statements of why, of what exactly you did. And then you might also want to have affidavits from other lawyers testifying that you're a good lawyer and know what you're doing, but principally also to help explain what the hourly rate is in the community. Now, under EJA, that might not be necessary because you often cap out at $200, but it's useful to have these affidavits. And then in EJA, you have to actually do the inflation calculation. Now, it's reasonably simple math that involves knowing how to do, proportional calculations. But you have to do it. You have to go get the most up-to-date Bureau of Labor Statistics inflation data, compare it to the what inflation was at in 2006, and then extrapolate from the $125 hour per rate. So I just want to show, before I close, show some examples of this very briefly. So here's an example of a fee declaration, just one of mine that's relatively recent. I'm not going to go over it in any detail, but I just say that I'm the senior lawyer on the case. That I would put that in paragraph number 1. It says my credentials, where I went to school. It says what I did, where I was working when I worked on this case, what my office does. So I say that my office, which was Public Citizen at the time, where I worked for 20 years, we worked on consumer health and safety regulation, freedom of information, access to the courts, First Amendment law, consumer law, just trying to describe that we know what we're doing, and then describing, again, the narrative, what I did on this case. So that's what we would do. So for instance, this case had to do with class actions and enforcing rights under class action law, so I point out that I've testified before Congress on class actions and have been a part of it. An American Law Institute project on class actions. So that's an example. Let me show one other thing, which is what time records look like in a case. Now I'm going to show you a very old one, so this is a little embarrassing. I think this may have been the first set of time records that I ever did. But the reason I'm using these is to show you the level of detail you might want to do if you don't want to get your fees cut. So for instance, I have an entry that says letter to client, but instead of saying just letter to client, it says letter to client explaining possible causes of action. So I have, and it says 0.4, that means I spent 0.4 of an hour, 0.4 of an hour, working on the case, instead of just saying I spent an hour, I spent a half hour, because you want to show the court that you're not overcharging, that you're just, and that you're calculating in tenths of an hour because you're trying to be as reasonable as possible. I'll use one other example, and then I'll end my presentation, which is that instead of saying on this particular date, and this is the third entry on this time records program that I'm reading from, time records list that I'm reading from, instead of just saying I did some research on the case, I say introductory research on the validity of the due process claim regarding property interests, and reading directly relevant cases and statutes, and then I put the amount of time, 0.8. In other words, 0.8 of an hour. So that's how you do it. And I hope this has been useful, and I look forward to any comments that people may have.
Okay, thank you very much, Dr. Wolfman.